Welcome back to Unfair Housing. I'm Morgan Cardinal. As a reminder, this podcast is not meant to be an exhaustive discussion of the history of housing segregation and housing discrimination, nor is it meant to create division or instill guilt, but rather to educate our listeners on what shaped our neighborhoods and our social perspectives so we can be better guided in our efforts to improve our future and avoid repeating the mistakes of our past. Keep in mind, discrimination is a heavy topic. So, as always, we ask that you please take care throughout this journey and pause episodes to take a deep breath when needed. Also, we welcome comments and lively discussion on the topics we raise, but we ask that kindness and consideration be used when making and responding to comments, and that you refrain from using threatening or violent language. Lastly, we have a prologue episode for those interested in a deeper discussion on how we got to today's topic, and we encourage you all to take time to listen to that. Over the next several episodes, we're talking about building suburbia after the Civil War. So let's get into it. Zoning played a critical role in the development of suburbia and is the most common form of land use regulation throughout really the world. As far back as the Roman Empire, we see height regulations for buildings and requirements that cemeteries be constructed outside of city limits. Similarly, in medieval London, nuisance laws prevented ownership of tigers and lions in the cities and limited crowds of very poor people, all for the sake of public health. This would be an example of zoning. A restrictive covenant is slightly different than zoning ordinances, but forms the base of what would later become codified zoning laws. Restrictive covenants are provisions between, or conditions agreed to by, private parties in a real property or estate transaction that limit the buyer or grantee's use of the property. Generally, the party that benefits from a restrictive covenant gets rights from such covenants. For example, two parties may agree to limit the height of trees on their property so they do not block the view of the neighboring property. This agreement would be a restrictive covenant. However, restrictive covenants can have more serious outcomes. For example, in the famous 1948 U.S. Supreme Court case, Shelby v. Kramer, the court struck down the enforcement of a restrictive covenant which provided that only Caucasians may hold title to real estate because the covenant violated the Equal Protection Clause of the 14th Amendment. Zoning, as we know it today, largely began to develop in the U.S. between the turn of the 20th century through the 1940s. The U.S. took a page out of the playbook of industrialized nations, such as Germany, to really develop patterns and regulations for dividing cities and towns into commercial and residential neighborhoods. During this period, commercial property was largely industrial factories and came with pollution, crowding, and disease. This practice of dividing cities is attributed to Edward M. Bassett from New York, who is credited as the father of American zoning. Zoning, as we understand it today, has had a vast and heavily researched history. Today, we'll hear from expert Sonia Hirt, Dean and Hughes Professor of Landscape Architecture and Planning at the University of Georgia College of Environment and Design, on the history of zoning in the U.S. and some of the uniquely American problems that have come with these practices. Professor Hirt, welcome to the podcast, and thank you so much for joining us virtually and sharing your time with us. We understand that you've done a lot of research in the areas of zoning and planning. Can you tell me a little bit about your research areas?
My educational background is in architecture and urban planning. And as you can imagine, urban planners deal a lot with zoning. Yet, something very easy to miss. A lot of people think that planning and zoning are almost identical. Nothing can be farther from the truth. Planning is you envision the world as you wish it. Zoning is just an instrument to implement the vision. There are 500 other instruments, like, for example, tax policy, many other instruments. But zoning is a powerful instrument, potentially the most powerful instruments that urban planners in the United States have. So as a result of it, there is a lot of conflation between planning and zoning. They are not the same. And as a matter of fact, to an extent, it could be said that the fact that they are so in the public's mind not separated is partially one of the problems why our zoning is not as well graded as it is in other countries, very diplomatically. So zoning is just an implementation mechanism. And zoning is not at fault for doing anything by itself. It's how we write the zoning laws. It's the problem. The actual text of the laws and how they are applied. Every country has zoning of some type. So by itself, it's necessary. Perhaps there are problems with the way that we zone our cities, but that's, again, not a problem of the principle of zoning, but simply how we have used it. If you take an extremely broad definition of zoning, if zoning is, all that it is the division of a territory in zones, then I can claim that every walled city in the world was zoned because there were the insiders and there are the outsiders. So if you take such a broad definition, I guess zoning has existed since the beginning of human settlements. But contemporary zoning, the way that we do it today in the United States, you very accurately pointed out, dates back to the early 1900s. Restrictive covenants, to the best of my knowledge, have existed in the United States. Don't quote me, well, I'm in public, but anyway, maybe 50 years, 100 years before zoning. So they are older. But the point is, restrictive covenants are generally things that are created and enforced by private parties. Zoning in the United States is a municipal law. So one is an action by the private sector and the other one is an action by the public sector. So they are different. To an extent, there is also a scale of application. A restrictive covenant usually covers a neighborhood. A zoning map and ordinance usually would cover the entire territory. But for zoning enthusiasts like myself, I can come with some complications of why this boundary is not absolutely perfect too, because as a matter of fact, the first zoning regulations in the United States started by being regulation at a neighborhood level before they became municipal. So there is a difference, but like if you look at many cases, you can see sometimes how things get mixed up. So that's another difference. So a restrictive covenant serves the interests of the particular people in the particular neighborhood. When you purchase a home, you have to oblige to these restrictive covenants, whereas zoning, being a municipal law, is supposed to, reflect the interests of all citizens. So to be sure, restrictive covenants are older. They're generally private. And I would say in the United States, restrictive covenants are one of the most powerful roots of zoning. So as you said, they borrowed a bunch of ideas from Europe. That's true. If you look at early zoning ordinances, apparently they were reading these restrictive covenants. As a matter of fact, Edward Bassett, who you quoted as popularly known as the father of zoning, articulated this in one of his pieces, I believe in 1913 or 16. He said this is the problem with the restrictive covenants, because they cover neighborhood by neighborhood. And so they are insufficient. What we need is a municipal-wide thought. Even the restrictive covenants are not an American invention. So actually, to my knowledge, again, there could be older ones, but for example, they were first used in England after the Great London Fire of 1666.
Okay.
So and actually there's some literature that they even existed before the Great Fire. So the point is that we didn't invent either zoning or restrictive covenants. We just developed them as our own traditions and eventually married them. So about, say, discrimination and restrictive covenants and zoning. Massive literature exists. A restrictive covenant, you have some upscale area in Boston, for example. Actually, if I'm not mistaken, the first restrictive covenants, 19th century restrictive covenants in the United States are in the city of Boston. And so, yeah, surely they made rules like, these houses in this neighborhood can be only purchased by somebody who is not of this demographic characteristics. They were used against all kinds of groups. And when zoning comes, as a matter of fact, there's an interesting moment in the late 19th century in California. Because some people say that the first real municipal zoning ordinances actually date from certain California cities such as San Francisco. What that means is that there was a lot of commercial laundries in San Francisco. And a laundry was actually a dangerous thing because there's fire and boiling water and there was no fire codes. It's dangerous. So for public health reasons, I think they were probably right that it's really the propensity of fire was actually higher. So they decided to say that laundries, commercial laundries, other businesses that have boiling water, even restaurants, maybe should be separated from the residences. So that's actually not a bad idea at the time. We don't have these problems today, but they did then. How do we know there was race behind it? Because once the regulations were written, they were never applied to anyone who was not of Asian origin. So they were specifically written. They may have not been written that way, but they were applied only to people of Chinese origin, because that's, it's California. That's where a lot of the immigration was coming from Asia. So it wasn't actually discriminating against Hispanic or African Americans. It was specifically the Asians. So, and then early zoning carries on with this tradition. Some cities in the South, like Baltimore and Birmingham, before they had the kind of categories you mentioned, like residential and commercial, they really had zones that were called black and white. It's really black and white. It couldn't be more clear. In essence, that this is not a practice that can be continued. And then explicitly racist language, to my knowledge, in restrictive covenants went all the way to the 40s, when there is another case, which now the name I can't remember, which actually said that even in private regulations, you cannot use explicit racial categories. Zoning has been used to exclude people, not just only by race, by ethnicity, by income. No one can possibly argue against that. But what I'd like to caution people when they ask me, well, zoning just must be bad. Why do we have it? Is that this is kind of a narrow, it's just one segment. At the time, in some ways, zoning really was necessary because, as you said, the factories were so polluting that really there had to be some separation between residents and polluting factory. A lot of the middle class, even the lower middle class, regular workers going to factories were delighted there will be zoning. And the labor unions supported zoning. Why? They call it poor man's law. Because if you're rich, you're going to get a carriage or a car in the 20th century, you're going to live 20 miles from town, and you're going to be bothered by the factories and the various poor people. You solve yourself. You don't need zoning. But if you're a worker and you want to live somewhere that's relatively decent, zoning for them was actually their protection. That was what prohibited a factory from locating next to their very little home. So I think the pollution, the fires, the concerns of regular people who were putting a lot of political pressure of let's do something about it so we don't have to live right next to the factory. It was all putting this pressure. And at the same time, speaking about fathers of zoning, there is a guy, I believe his name is Henry Montagu, I have to look him up, who actually right at that time, I think it's the year 1913, translates all the German zoning laws. So, and then Bassett sees that, they all begin to travel to Europe. So this is also a moment when they all are educating themselves by going to Europe. And so all these things came together, and actually, he came up with what really is the first largest comprehensive zoning plan in the history of the world. They always use these three words, which are the words that justify the police power in the United States, because zoning is actually an exercise of the police power. So it was also health, safety, morals, and well-being. Now you can understand that what's morals is tricky, but the point being, that's the language that was used. So in short, I think the people who were really getting benefits, and that's how it was portrayed at the time, were homeowners. Now, you got to think that home ownership was much lower in the United States 100 years ago, but it still was more than it was at the time in Europe. So they probably were never really protecting the really poor, but they were probably looking to protect the lower middle classes, especially those who were aspiring to have a home, because it was it's a great political bloc. But to give you one example, so in the United States, the famous zoning case that kind of so New York zones in 1916, but for 10 years, no one was sure whether the Supreme Court would have a problem with it. So in 1926, there is a case, Euclid versus Ambler, where the Supreme Court, Euclid is a suburb of Cleveland, Ohio, where they said, no, it's okay. Everyone can have zoning now. It's legit. So first of all, Euclid, this town, did its zoning ordinance, and who is opposed to Ambler Realty, a business. That they actually wanted to build industry. So here you have a business being against municipal zoning because they thought they'll make more money if they built what they want rather than what the zoning ordinance permitted them. And then, of course, the case, and then, of course, there was a dissent, and I believe that the person who wrote the dissenting opinion was Judge Sutherland, if I correctly remember. And he says that if you begin to divide people like that, that actually you eventually are going to divide them by class. And so he was against it. So yeah, there were a lot of people against it. I mean, think about it. Zoning was proposed, first was implemented in Germany in 1876. It comes to the United States partially in 1913, 1916. And it takes another 20 years for all of America or all big towns to have zoning. So there must have been opposition. And the opposition was not necessarily, I think, because there was some opposition like that you're dividing us. Why should some people have this and other people not, and so forth and so forth. But I think to a large extent, the opposition was coming from a place that you'd be surprised by. People thought this is 1916, 17. You know what? They thought it's a Russian idea because after the Bolshevik Revolution, so there were articles written that zoning is worse than communism. And why is zoning worse than communism? Because ultimately it amounts to the public regulation of private property. And so that was like, what? You're going to be telling us now what we can build where? That's a communist idea. So actually there were people from the zoning advocates. I can't remember the name of the guy. It's not Bassett, one of the other founders. He had to write articles to the newspapers to explain he's never been to Soviet Russia. He's not a communist, you see, and he doesn't even speak Russian. So, I mean, it seems absurd today, but here is part of the opposition. All you need is a residential zone. It does not need to be single-family residential zone. And so it's the single-family residential zone, really, in my opinion, that is the American invention. Everything else we borrowed. We developed it, but we borrowed. But the single-family residential zone, now that really is an American thing. And it's very, we've had it for 100 years. It's perfectly, what I'm trying to say is not that there are not single-family homes in other countries. Well, of course that there are. It's just what is really unusual, well, still my European mind, which is why I wrote a book on zoning, just to understand it, is that the idea that you literally cover 80% of your town with one type of land use and would prohibit everything else, that really only happens in America, that I know of. Now, I haven't studied 200 countries in the world, and there's some, people say Australia and Canada would be similar, but as compared to any West or East European country that I know, no one has that, at least to the extent that we have it here. And I don't know, but there is something about the American cultural experience that really puts primacy on the private home, your private imperium, with the yard and the space. Most people in most countries are accustomed to living in greater density, and they're simply not bothered by it. In the year 681, William Penn establishes the city of Philadelphia. And when he established the city of Philadelphia, this was before anyone had heard the word zoning. And that's 200 years before. And he wrote in his instructions how he envisioned the future city, how an ideal city would emerge in the United States, which was not a country, but, at the time, just a colony, of course. And he said that he hopes and prays that Philadelphia and all American towns will be built in a way to be very different from European cities, and they will be cities for country gentlemen. The single-family home is the application of this idea that a city can be a city for country gentlemen. You have your downtown, but at the end of the day, you go to a single-family home, and you're almost like in the country. So it's whether there was some rebellion against what they were observing in Europe, which was already industrializing and terrible place to live for most people. What they saw is a green promise, lots of land, and that was like really attractive thing, seemed wonderfully empowering. We don't have to live like them on top of each other. And since I came from abroad, I was actually surprised to see how American zoning works, because I've never seen an American zoning ordinance before, and it was a total shocker. So I decided to dedicate about 10 years to understand how this instrument developed, and that resulted in, my publications in a book, which, came to be relatively highly regarded. And I'm only going to bring up the title. It's called Zoned in the USA. And the point is, like, people think, oh, it's about, zoning in the USA. But my point is to show that the way we zone in the USA cannot be found in any other country. So it's a unique thing. Now, it could be a good thing, it could be a bad thing, but it's a unique thing. And because it's a unique thing, it just deserves more research. That's been my story so far.
If you're interested in reading more about Professor Hirt's research, check out Zoned in the USA, The Origins and Implications of American Land Use Regulation, detailing Professor Hirt's research on why American cities, suburbs, and towns are so unique. As we heard from Professor Hirt, the U.S. Supreme Court has taken up the issue of local zoning practices a number of times. The following cases are particularly noteworthy for their impact on modern zoning. In Buchanan v. Worley, in 1917, the matter at issue was a racially based zoning practice passed by the city of Louisville. Specifically, the law didn't allow whites to sell property to blacks in a majority white neighborhood in Jefferson County, Kentucky. In 1914, the city of Louisville approved an ordinance that stated in relevant part, "It shall be unlawful for any colored person to move into and occupy as a residence, place of abode, or to establish and maintain as a place of public assembly any house upon any block upon which a greater number of houses are occupied as residence, places of abode, or places of public assembly by white people than are occupied as residence, places of abode, or places of public assembly by colored people." In short terms, Black people were legally not allowed to live in a neighborhood if mostly white people were already living there. Worley made an offer to purchase, which was accepted by Buchanan. At the time of the offer, the property was located in a 10-lot block of Louisville, and 8 of those lots were owned by white people. It is interesting to note that the case actually resulted from the white owner, Buchanan, attempting to enforce specific performance, the actual purchase of the property, by Worley, the Black potential buyer, despite the ordinance making the contract effectively unenforceable based on Worley's race. Worley had refused to pay the full price of the contract since the ordinance would prevent him from living at the property. When the case made its way to the Supreme Court, the court asked, "Can a white man be denied consistently with due process of law the right to dispose of his property to a purchaser by prohibiting the occupation of it for the sole reason that the purchaser is a person of color intending to occupy the premises as a place of residence?" In lay terms, it was determined unconstitutional to prevent a person from selling or deeding their property due solely to the color of the potential purchaser or grantee. The Supreme Court ultimately found that Buchanan's constitutional right to his property, and by extension his right to do with his property what he wanted, was infringed by the city ordinance, and therefore the ordinance was unenforceable. Further, the court held that the prohibition on selling property to someone based on their color was in direct conflict with the rights afforded all citizens under the 14th Amendment, stating, "While a principal purpose of the 14th Amendment was to protect persons of color, the broad language used was deemed sufficient to protect all persons, white or black, against discriminatory legislation by the states. This is now the settled law." You'll see as our discussion continues that while the U.S. Supreme Court found that a race-based limitation on property rights by local governments was unconstitutional, private individuals and neighborhoods found other ways to make sure their neighborhoods remained separated. As Professor Hirt mentioned, in November 1922, the Village of Euclid adopted an ordinance establishing a comprehensive zoning plan for regulating and restricting the location of commercial and residential properties, including the lot areas to be built on and the size and height of buildings. This is the first case that established a federal test for zoning policies and created comprehensive land use planning. The entire village, which was considered a suburb of Cleveland, was divided by the ordinance into 6 classes of use district, 3 classes of height districts, and 4 classes of area districts. The court spent some time explaining that the expansion of industry in Cleveland had started to spill into the village suburb, which prompted the need for zoning regulations in the village. Meaning, the idyllic village didn't want the dirty city rubbing off on them. However, this case was brought when a landowner, Ambler Realty, whose property covered multiple districts, determined that this property was limited in development because of the restrictions of the specific districts. Specifically, the property was in Use District 2, 3, and 6, with Districts 2 and 3 allowing for residential building and some commercial, and District 6 allowing for industrial operations. However, the height allowance would not allow for apartments, hotels, or other public or semi-public buildings allowed under Use Districts 2 and 3. More simply put, some of the land could only be used for commercial purposes and the development of trade, and the remainder could only be used for industrial purposes, meaning any residential use was not available. The landowner sued, arguing the zoning ordinance violated the 14th Amendment because it deprived landowners of property rights without due process of the law. Specifically, Ambler Realty's position is the ordinance as written limited their use of the land for development, so much so that it was equal to a taking of the land and much of the land's value was destroyed. The court reasoned that the segregation, interesting choice of words here, of industries, commercial pursuits, and dwellings to particular districts in a city, when exercised reasonably, may bear a rational relation to the health, morals, safety, and general welfare of the community. It ultimately held that the ordinance was a valid use of the village's authority. With this framework in place from the highest court in the country, we see a development of modern suburban towns, segregated due to health and safety concerns created by industry. However, these new single-family suburban paradises would rely on private restrictive covenants to achieve discriminatory outcomes to keep minorities out of their idyllic neighborhoods. But more on that in future episodes. Post-Civil War, we see the country develop industry, cities, and work toward creating wealth for some. But we're about to reach an economic crisis that will take decades of recovery, the Great Depression. During this period, those already disadvantaged will not receive the benefits of many of the recovery efforts under the New Deal. So stay tuned for next week's episode, where the team will take us through the Great Depression and the impacts on the housing market. Thanks for joining us for this week's Unfair Housing Podcast. Remember to like and follow and to stay updated on all things unfair housing. We look forward to having you back next week as we dive into the New Deal era. Hey folks, Morgan here again. We hope you're enjoying the Unfair Housing Podcast so far. Thank you for joining us, and remember, if you or someone you know is experiencing housing discrimination, or if you would like to schedule a fair housing training, contact our Fair Housing Unit at 800-875-8785. That's 800-875-8785. To see if you qualify for other legal assistance, contact the CLS helpline at 800-405-1417. Once again, 800-405-1417. And don't forget, give us a like and a follow. And please share the series with your friends and family. Also be sure to follow CLS on Instagram, Facebook, and X.